All right. I don't know if you can see it, but at the top left corner it tells you that this is now streaming live on YouTube in accordance with your request. I would also inform you that when you in this case, you have chosen to file a motion for a speedy trial. Your attorney, Ms. Jessica Gonzalez, you now have the floor, ma'am.
Thank you, Your Honor. Before I begin questioning Mr. Sanchez, there's a couple more dates that I would like to put on the record that should be noted in the court's file. As the court stated, or I explained to the court, the offense date is September 16th, 2018. I'm sorry, did I hear something?
I'm sorry, that was my alarm. I'm so sorry.
Okay, sorry. Okay. So the next date is my client was given a court-appointed attorney at the time he was arrested, and there were several court appearances with that attorney as the appointed counsel. I was appointed to the case on January 21st, 2020, and on that date, the court online records reflect that I demanded and asked to be set for a jury trial. On February 24th, 2020.
Hold on.
I'm sorry, Judge.
You demanded a jury trial when?
On January 21st, 2020.
All right.
On February 24th, 2020, I filed the defendant's first motion requesting or alleging a speedy trial violation, a right to speedy trial violation.
All right.
On June 5th, 2020, this court held a hearing on that motion with Mr. Sanchez present and testifying.
Anything else?
Time, yes, Your Honor, sorry. At that time, the court denied that motion and allowed Mr. Sanchez to file for an appointment of an investigator. And on October 16th, 2020, my client filed a waiver of his right for a jury trial and asked the court for a bench trial.
All right.
Because there was no response from the state as to whether or not that was going to be agreed to, on October 29th, we held a hearing on that jury waiver. There was still no response at the time of that hearing on the 29th.
All right.
The second motion that the defendant filed for a speedy trial violation was filed on, November 13th. And that is the date that I have in my notes that we were given a bench trial setting for December 10th.
Alrighty.
On December 8th, I received emails from the court and notices that the December 10th bench trial was reset by the court.
All right.
And on December 10th, I filed the third speedy trial request to dismiss the charges for violation of lack of due diligence and violation of the speedy trial right. And that's the motion that's before the court today.
Pardon me. All right, your motion, proceed.
Okay, thank you, Your Honor. Now, Chris, I call Christopher Sanchez to testify.
Mr. Sanchez, raise your right hand again. Actually, you've already been sworn.
Yes,
You understand that, right?
yes, I do, Your Honor.
Already.
May I proceed, Your Honor?
Yes, you may.
Mr. Sanchez, can you please explain to the court what was the first bond condition that you had for your release while you were pending trial?
I had to immediately get an interlock installed in my truck.
Okay, and have you
Within,
had
like-
an
Say again?
have you had interlock installed since the end of 2018?
Yes.
Okay, and approximately how much are you paying a month for the ignition interlock?
Like, about $80 to $90.
Okay. And then have you had any other conditions of bond on, have you have any other conditions on your bond?
Yes, I had the ankle monitor for
Okay,
about 3 months. That cost me about $300 a month. And then they took it back and put the breathalyzer, and then I got the pills that I got to pay every other day, 3 times a week.
how long have you
Like-
been on the anti-abuse pills?
Since probably the middle of this year, close to like 6 to 5 months. I feel it's been a while. I can't really recall, but it feels like 5 months. I feel.
So did you make payments for ignition interlock and anti-abuse in October
Yes,
and also in November?
correct.
And as far as we're here on December 16th, what have you paid for this month?
I've been paying the pills
Okay,
for now, and then at the end of the month I'll have the interlock.
okay. And then also the same for January, correct?
Yes, correct.
How much on average would you say now that you have ignition interlock and the pills, how much do you average that you're spending a month while you're waiting trial?
It can vary from like 210, 220.
Okay. And has this created a burden for you while you've been awaiting trial?
It has. It really has. It's to the point where I have to figure out if I'm gonna eat or I gotta pay this, which I have to because I want to stay out of jail. So
Now, with regards to your defense, you and I have spoken about your defense, correct?
yes,
And you believe that there was a witness that could come in to testify, correct?
correct.
Do you remember what his name is?
Yes, Devin. I just don't know how to say his last name.
Okay. And did you learn that after the investigation that was done by the investigator?
I knew his name. I just forgot his name, but I knew he always wanted to help me when I first had spoke to him.
Okay. When did you first speak to him about the arrest and the assault?
It was like a month after it all happened. He kind of came up to me and told me, "Hey, are you okay?" I'm like, "What do you mean?" And I didn't know he actually was the one who helped me. It was like a month after.
Okay, since it's been a few months since we talked about this in front of the judge, can you please remind the court before you were arrested, what happened to you with regards to the assault?
I was on the way to my truck to grab my jacket, and
Your Honor,
just
I'm going to object at this point. This is not relevant to the issues of prejudice or the defendant's assertion of the right, the reason for the delay. This has nothing to do with any of the Barker v. Wingo factors.
Whether or not this missing witness, what this witness would testify to actually does go directly to the Barker Wingo factors and whether or not he's been prejudiced. The seriousness of this witness and what this witness would be able to provide to the court in defense of this charge.
Your Honor, may I respond?
Of course.
First, the defense actually needs to demonstrate that the witness cannot be produced, which they have not done.
That was actually done last week when we were here on the 10th and the witness was subpoenaed and the witness did not show up.
What has been demonstrated, Your Honor, is that the witness is reluctant to testify, not that the witness cannot be produced. That's what the writ of attachment is for.
No, the subpoena was to order the witness to come in and the witness disobeyed a subpoena.
I believe that the objection has merit. However, the problem is that I know that you have attempted to produce him. The prejudice may be that he was a willing witness way back when and is now an unwilling witness at this point. If you will get to that instead of the specifics of what the witness will testify to,
Yes, Your Honor.
that's more relevant.
Yes, Your Honor. As long as I just wanted to provide the background to the court, as long as the court understands what this witness was for, I'm happy to skip to that part.
Well, the fact that an officer of the court tells me that this was a witness for the defense is sufficient. As far as details of that, I don't necessarily need to get into that. So
okay,
the objection is sustained, but I think you know what I need or want.
Yes, Your Honor. So, Christopher, after you were telling the court about after the arrest, you'd spoken to the witness, Devin. About how long after the arrest did you speak to him?
It was about a month because I didn't go out for a while. I didn't do nothing. I stayed in and I had just bumped into him and he kind of came up to me. I couldn't tell you exactly, but it was about a month after.
Okay. And did he indicate to you at that time that he was willing to help you? Well, first of all, did he check on you after the assault? Was he asking about your health?
Yeah, when he first saw me, that when he finally saw me again, yes, he asked me. And I didn't know what he was asking at the time because I didn't know he was there.
Okay. And then did he indicate to you that he was willing to help you with whatever you needed?
Yes. Yes, he did.
And after that conversation, did you run into him again?
Not really. I don't think I did.
Okay.
But no, just like that time, and then I told my attorney at the time too.
Okay. But again, at that initial conversation, he said he was willing to help you, correct?
Yes, he was. He seemed very eager to help me because he saw what happened. He was just like he wanted to help me out.
And were you present in court on December 10th?
Yes.
And was that witness, did you see him in court when we were on the Zoom video conference? Did you see him there?
No.
Have you learned that he has been unwilling to cooperate with your defense?
Yes.
Thank you. I'll pass the witness.
So, Mr. Sanchez, when was your first bond violation?
Objection, Your Honor, relevance.
Well, Your Honor, if the defendant wants to complain about the onerous bond conditions, then the defendant also needs to explain the numerous violations that he's committed on those bond conditions and the reason why additional bond conditions were ordered by the court.
But it still doesn't negate the fact that there was ignition interlock from the time that he was arrested for this offense just because of the charge alone.
I'm going to overrule the objection because you're trying to show prejudice, which is it's already, as far as I'm concerned, you've established it. But the inquiry by the state is appropriate. But limit that some, Mr. Edelman.
Yes, sir. So, Mr. Sanchez, would you please answer the question?
Yes. What happened was it was.
I didn't ask what happened, sir. I asked when was your first violation of your bond conditions?
I can't really remember. Like it was, I think it was. I'm not. I couldn't really tell you that on the top of my head. I can't tell you. But I can tell you what happened.
So you remember what happened, but you don't remember when it happened?
No. What happened
Does
was
August 19th, 2019 sound about right?
If it's on the record, then yes. If you have it in paper, then yes.
And what about your second bond violation? You remember when that happened?
No, I really don't. I just know what happened. I really don't have a calendar with me at the time.
Does August 28th, 2019 sound about right to you?
If it's on there, I'm gonna have to say yes. But like I'm saying right now, I don't know exactly the dates. I don't have anything in front of me to tell you that, like, to be certain on my half.
And do you remember what the court did in response to your two bond violations?
I got an increase on my bond. I was in jail for like about a week.
All right. What about your third bond violation? Do you remember when that happened?
That was probably the middle of this year, because this was when I got the pills. I just can't tell you exactly what date or month. I just know it was this year.
Are you sure about that?
I got the medications this year. I haven't been taking them. I didn't take them 2019.
Your Honor, at this time, I'd like the court to take judicial notice of the court's file, which would indicate that the third violation report was submitted to the court on September 27th of 2019.
The court will take judicial notice.
So what about your fourth violation of your bond conditions, Mr. Sanchez? You remember when those occurred?
I didn't know I had a fourth. I thought I was doing good. I thought I've been doing good. I've been trying to follow everything I've been told.
And then what about your fifth violation? You remember when that occurred?
I'm telling you, I didn't know. I really didn't know I was violating that much. And I'm very sorry. I really am doing everything I have to do to stay out of trouble.
Now, you were initially arrested on September 16th of 2018, correct?
Correct.
And you had counsel appointed to you shortly after your arrest, correct?
Yes, Trevor.
And how many pretrial settings did you have between your arrest and your first violation report?
Yeah, man, these questions can you repeat that again?
Do you remember how many settings elapsed between when you were first arrested and when the first violation report was submitted to the court?
I wouldn't be able to tell you off the top of my head, and I'm very sorry that I can't.
Do you remember approximately what amount of time elapsed?
Again, I don't have anything in front of me to tell you and to be certain, because I don't want to give you wrong information.
Now, you had counsel appointed to you shortly after you were arrested. And then a month after your arrest, as you told the court, this witness, Devon, approached you and said that he wanted to help you in any way that he could. Is that correct?
Correct.
And that you told this to your attorney?
Yes, I did.
And did your attorney do anything
He
make
said he
any
was.
contact with your witness?
He said he was. He told me, he asked me everything, where he worked. I gave him all the information, and I thought he was taking care of it. Every time I try to get a hold of him, he was always on vacation.
And so after you told your attorney that you had this witness who was willing to help you, then you decided to reset this case for a plea. Isn't that correct?
No, I've always was trying to fight it because I was fighting for my life. I've always wanted to fight this.
Who was the previous attorney?
His name was Trevor. I don't know his last name.
Trevor Burgess, sir.
Thank you.
So your case was initially set for a plea on August 15th of 2019, according to the court's records. A number of violations of your bond conditions then ensued. And then finally, on June 21st of 2020, the case is set for a jury trial. A number of other bond violations ensued. Isn't that correct?
I mean, I did get on the pill, so I know I violated.
Now, you have the current address for this divan.
I don't.
Is that correct?
I just have the name.
Well, if your attorney was able to serve this witness with a subpoena, it would seem to imply that there is a current address available to you, would it not?
Yes, but I don't think she can give me that. So I can go.
Then it is reasonable to assume that the witness can be contacted. Isn't that correct?
Yes, but I don't have his number.
And if the witness can be contacted, then there are mechanisms available to your defense counsel acting through the court to produce the witness to testify as to whatever that witness remembers. Isn't that correct?
Yes, we're trying to get him back in here so that we can testify. And so
you don't actually know that the witness is unavailable. You just know that the witness is reluctant.
All I know is that we're having trouble trying to contact him and trying to get a hold of him to communicate with him, and we haven't had any luck. That's all I know. I also tried to look him up on Facebook, and I found him. I tried to contact him, but see if he can, because I didn't want him to get in trouble. I mean, there's no reason for him to get in trouble. He actually helped. He saved my life that day.
And this witness was so important to you, to your defense, that you made sure to maintain contact with this witness in the intervening 2+ years that this case has been awaiting on this court's docket.
Well, I didn't see him after a while, and I never ever saw him afterwards. So
That's not what I asked. This witness, who is so important to your defense, you made sure to maintain contact with this person, didn't you?
I didn't. I don't even know the guy that well. I just knew the fact that he helped me out. He came up to me and told me, "Hey, are you okay?" And when I figured out that he was the one, that was the reason everyone stopped beating me up on the floor, because he came in and rescued me. And I ran. I didn't know that at the time. I just ran. He told me a different side of the story that I knew. I just knew that I got up and I ran. That was it. I didn't know anybody else helped me.
So this witness who reached out to you a month after the alleged offense, you didn't make sure to keep this person's current contact information, forwarding address, any way to maintain them so that you'd be able to produce them if you needed to at trial, did you?
I gave all the permission to Trevor, and with God's grace, I thought he was actually doing something. I thought he was really helping me out. I thought he was actually moving forward on it. I assumed. I should have never assumed. I put my faith in him, and he lost the witness.
And you haven't brought Mr. Burgess to testify to any of those facts today, have you?
I mean, he's not my attorney anymore.
He was your attorney, and that's also not what I asked. You haven't produced him to give his side of the story of what happened, did you?
I'm just going to plead the fifth on that. I don't know how to answer that.
Your Honor, will you please instruct Mr. Sanchez to answer the question?
Mr. Sanchez, do you have an answer to that question?
We don't have him here. I don't know what.
Sorry?
We don't have him here on Zoom with us. I didn't know he was supposed to be on the trial.
What was your question, Mr. Edelman?
That the defense has not produced Mr. Burgess to substantiate what Mr. Sanchez is telling the court now, has he?
And Your Honor, I would object at this point. We've already clarified that the witness has been found and located and was properly served by subpoena to be at the trial setting on December 10th. That's already been established. Whether or not my client lost contact or saved contact, all of that's irrelevant. The witness has been found and located and is uncooperative.
All right. You're correct about that, but his question was, has he attempted or you attempted to have Mr. Burgess come in as a witness? Do you have an objection to that?
I think it's irrelevant whether or not the prior attorney is going to come in to testify about
Sustained.
a witness. Thank you.
I have nothing further to ask Mr. Sanchez at this time.
Thank you, sir. Any other witness, Ms. Gonzalez?
Well, I have redirect on a couple issues that were brought up by Mr. Edelman. Mr. Sanchez, Mr. Edelman went through several violations with you while violation reports had been filed against you. With those reports, were you given an opportunity for a hearing on those bond violations?
No.
Were you ever given a chance to explain anything to the court as to why there were violations?
No.
Were you ever presented with any evidence of those violations?
No.
Now, when we came to court for the bench trial setting on December 10th, did you ask the court for a reset?
Can you say that one more time? I'm sorry.
When we came to court for the bench trial setting on December 10th, did you ask for a reset?
I really can't remember.
Okay. When we came to court last week, did you ask for a different court date?
No.
Okay. Did you want to have trial on December 10th?
Yes.
Since I was appointed as the attorney of record and I demanded a trial setting on January 21st, have you ever asked the court for a reset for that trial?
No.
Have you been wanting your trial ever since then?
Yes.
And in fact, haven't you gone to the length of waiving your right to a jury trial and to get a bench trial in order to get this trial to happen faster?
Yes.
Thank you. I'll pass the witness.
Your Honor, may I conduct a brief re-cross-examination?
Yes, sir. That's your right.
Mr. Sanchez, on any of your violation reports, did you ask the court to hold a hearing to substantiate the allegations of violations?
Well, at the time, I tried to explain to Trevor, and I didn't know you can do that. But me explaining to Trevor, I was hoping he can actually do something, but I didn't know you can do that. But when I had Trevor as my attorney, I explained to him in detail what was going on, what was happening, why these things actually happened. And I thought he was going, he told me he was going to the judge and he was going to go and talk to him and explain. But I mean, I'm not in the room when he does it. So.
Fair enough. Unfortunately, or perhaps fortunately for you, Mr. Burgess was replaced by Ms. Gonzalez. So let's talk about your 5th violation report. Did you ask Ms. Gonzalez to demand a hearing with the court to present your side of the story or to demand the evidence?
Did I? Can you repeat that one more time?
On your 5th violation report, which occurred April of this year, did you ask Ms. Gonzalez to demand a hearing with the court to produce the evidence substantiating the violations or to present your side of the story?
Yes.
Are you sure? You seem hesitant.
Well, I mean, I have to think about it because, like I said, it's really hard to remember a lot of things, especially being on the spotlight.
So the answer is you don't remember, do you?
I didn't say that. I said yes.
And then your previous violation report, which is alleged to have occurred in March 31st, you similarly requested a hearing on that?
Who was my attorney at the time?
That was Ms. Gonzalez.
And that was when again? What date was that?
March 31st.
Of what year? 2020 or 19?
2020.
2020. I'm about to say yes.
So when there have been bond violation allegations, you've had a mechanism to contest them, haven't you?
Repeat that again.
When there have been allegations of violations of your bond conditions, you've had a mechanism to contest them, haven't you?
No, I'm just using the law.
I think in a roundabout way, you do understand my question.
You're trying to make me say something that's not true, so no.
Nothing further, Your Honor.
Anything further, Ms. Gonzalez?
Nothing further from Mr. Sanchez. The one thing that I do want to remind the court is that when we had the hearing on June 5th with that speedy trial hearing discussing these bond violation issues and reports, we did bring it to the court's attention, and the court asked that he be continued on with both of those devices of the ignition interlock and the antabuse pill for a significant period of time before the court would consider removing one or either of those devices. And with that, I have no further witnesses and I'm ready to proceed. Well, I pass the case to the state if they have any witnesses or evidence.
I'm sorry, I did not. You kind of broke up. I didn't get what you said there.
Yes, Your Honor. At this time, I pass to the state for any witnesses or evidence to present to the court.
Mr. Edelman, anything else?
No, Your Honor.
All right. Ms. Gonzalez, you rest?
I do rest, Your Honor.
Mr. Edelman?
Rest, Your Honor.
All right. Argument, Ms. Gonzalez, this is your motion.
Thank you, Your Honor. What I'd like to present to the court, we've already gone through. This is now the second time requesting. It's the third technical motion, but the second hearing with regards to a speedy trial violation. The court did hear similar evidence at the last hearing on June 5th. However, at that time, the majority of the violations were due to, the court found, were due to the prior attorney's delays in the case. And so the court denied the motion. Furthermore, the court stated that the witness at that time, since Mr. Sanchez did not remember the witness's name or any other information and had not requested for an investigator at that point in time, that a lost witness, when we had the hearing in June, was a possible lost witness. We're now coming to the court asking for a third time to grant this motion to dismiss for lack of due diligence in violation of his right to a speedy trial. As I recited to the court, I have been on the case since January 21st, 2020. While there has been a pandemic during that time, I demanded on behalf of my client a trial setting back in January. More than 8 months have lapsed between then and now, where my client has asserted every point in time, he's asserted his right to a trial. Now, there has been a pandemic and there is an excuse for no jury trials. However, on October, I forget the date in front of me. Hang on one second, Your Honor. On October 16th. On October 16th, my client opted to waive that constitutional right of a jury trial in order to get him a bench trial setting so that he can have this matter resolved before a court of law in a timely fashion. There has been no evidence presented or offered by the state of Texas to provide reasonable reasons why we have not gone to a trial. We had a setting on October 29th for that hearing on that jury waiver. As far as November 13th, this case was set for that bench trial. And when we came before the court with the witness located by the investigator, with that witness subpoenaed, it was a court order ordering that witness to be present in court or via the Zoom app on December 10th. That witness disobeyed the court order. At this point in time, now that we're coming before the court requesting the dismissal for the speedy trial violation, we now have proof that we have an uncooperative witness, that we have gone to every single length to try to locate this witness and bring him before the court to be able to testify. And if we have to move to the next step of doing a writ of attachment, which I have filed for and we're prepared to argue, we're looking at, I think it's fair to say, we're looking at an already uncooperative witness. Now that he's disobeyed a court order and now that the judge is going to hold him in custody until he can come in to testify, he's going to be an entirely, completely uncooperative witness. And this witness is necessary and crucial for my client's defense for the offense of driving while intoxicated. Second, we've outlined the prejudice. The delay cannot be attributed from January 21st to where we are today from the and including that December 10th date. None of those delays can be attributed to my client. They can all be attributed to either the state or the court for delaying this setting, this bench trial setting. Because there is not a reasonable excuse or any evidence that has been offered before the court during this hearing to explain that delay, I am asking on behalf of my client, given the prejudice of the financial restrictions with my client, the fact that he has testified that he is spending over $200 a month for his bond conditions, that given that financial prejudice and the prejudice that he has lost a witness during the delay, we are asking for this case to be dismissed and violate because his right to a speedy trial has been violated.
Mr. Edelman.
Well, what really stands out to me is the manner in which the defense manipulates the timeline of events in order to try and generate a benefit for her client. And you can see it even beginning from the timeline of events that the defense laid out at the beginning of this hearing, starting at September 16th of 2018 and proceeding through the court's email from December 8th, sending notice to the parties that this case would be reset. The defense did not point out any of the numerous violations of the defendant's bond conditions that were alleged and that led to additional sanctions and bond conditions that have been the cause of a great deal of his financial stress. It's a conspicuous omission, and I think a deliberate one to create an impression that the prejudice suffered by the defendant is entirely attributable to the length of the delay rather than to the defendant's own conduct while he has awaited trial. Furthermore, there's the very interesting way in which the defense has gone about characterizing the witness that forms the backbone of the defense. Because right before ending her remarks, defense counsel called this witness a lost witness after several sentences in which the witness was described as uncooperative. Well, the defense doesn't get to have it both ways. Either the defense witness is uncooperative, which implies that the defense witness is still available, in which there is no prejudice for a missing witness, or there is a lost witness, in which case it doesn't make an awful lot of sense that the defense counsel has managed to locate and subpoena the witness. Whether the witness is cooperative or not is really beside the point of whether the witness can be produced and whether the witness still has relevant evidence to provide in the form of testimony. More to the point, the defense has not offered any evidence that the length of the delay is the cause of this witness becoming uncooperative or unavailable, depending on how the defense wants to characterize the witness at any given time. The defendant has only testified that he had contact with this witness once. That was presumably in October of 2018. The witness has not had any other contact with the defendant or with the defendant's attorneys in the intervening time, at least according to the evidence that has been provided to this court so far.
What's your objection, Ms. Gonzalez?
Yes, Your Honor. The witness was found and subpoenaed. I think it's reasonable for the court to assume that we have had contact with this witness if he was hand-delivered a subpoena. So that's a mischaracterization.
All right, I'll sustain your objection. Of course, I already heard all that, but go ahead. Mr. Edelman, finish up.
The long and short of it is, Your Honor, that the defendant has been complicit to a great degree in the delay that has occurred in this case, in the prejudice that he has suffered in the form of oppressive pretrial confinement and bond conditions. The defense has not produced a prior attorney to provide any additional evidence as to whether the defendant's request for trial through that attorney can be corroborated, which makes the testimony entirely self-serving. Moreover, the defendant was appointed new counsel in January of 2020, and it was not until October of 2020 that the defendant decided to waive his right to a jury trial and proceed with a bench trial. But the defense wants to characterize the entire span from January through November 13th as a delay attributable to the state because of its reluctance or refusal to allow him to proceed with a bench trial. The more correct characterization is that, again, Mr. Sanchez delayed in asserting his right to trial by opting for a bench trial rather than a jury trial. And the 45 days of delay between the defendants opting to waive a jury trial and the state deciding that it was in the best interest of justice is simply overwhelmed by the defendant's substantial delay that he has largely brought on himself. So for those reasons, the motion should be dismissed. And one final thought is that the state has at no time announced that it is not ready for trial or requested a reset of a trial setting. We're ready. We're ready to go. Now, if the court will accommodate us, we'll get Mr. Sanchez the trial that he seems to desire.
All right.
May I respond, Your Honor, to one point?
It's your motion. You may.
Your Honor, even through the arguments of counsel, and they did not opt to present any evidence to the court for this hearing, there's been no reasonable explanation that has been offered for why there was a delay. While it was only 45 days is two different payments that my client needed to make on those bond conditions. That there's been no evidence before the court that has been given for why there was a delay, and that delay is not attributed to my client. He has and has always demanded that speedy trial. As far as what the prior attorney's delay, the court has already ruled on that, and my client, while he disagrees with it, does accept that delay was found by the court to be attributed to him, even though it was not what he had wanted. What the delay that I'm talking about is since I've come onto the case since January 21st of 2020. And with that date in mind for the court, the burden shifts to the district attorney's office to be able to provide why it is reasonable. They have not met that burden through this hearing to show that it was a reasonable delay, and therefore it should be deemed by the court as an unreasonable delay. And when you couple that with the prejudice of my client, whether or not some of the bond violations, the reports, and the additional conditions may have been attributed to him, the fact of the matter is he's had ignition interlock on his vehicle since the date of his arrest, and that is only due to the type of offense he's being charged with. So no matter what, he was always going to have a financial burden on him, whether or not it was increased or just the ignition interlock. So for those two things, Your Honor, we are asking that the court find that his right to a speedy trial has been violated and that the case be dismissed.
I am going to deny the motion again, Ms. Gonzalez. I recognize that the defendant has, Mr. Sanchez has had to carry quite a burden as a result of behavior alleged to have been committed by him. A lot of the delay in the court's opinion has resulted from his behavior, his violations, because each time you get a violation, there is additional time and considerations that the court has to take along with the district attorney. It is not my impression that the district attorney at any time has asked for a extension or a reset or a continuance of this matter. Part of the biggest problem is the court's inability at this time to proceed to trial. And it is my fault that we did not go to trial on December the 8th?
The 10th, Your Honor.
The 10th, I'm sorry. That was my responsibility. I could not proceed because of technical matters that I am not proficient in. That's my fault. But I don't believe that under the total circumstances that the case should be dismissed for lack of speedy trial. It may be that you're correct, but at this point, I don't buy that for some of the reasons that I have established. I will give consideration to giving some relief to Mr. Sanchez. Specifically, Mr. Sanchez, when's the last time, you don't have to answer this, but when's the last time you actually drank alcohol?
I haven't had a drink.
When's the last time? You were charged with a violation in April.
You can say, but I wasn't drinking. I mean, I wasn't. I don't know, the machine. I was on my way to work that morning. I had to call somebody to come pick me up that morning because I was like, my mom, I don't know what's going on. So I was like, they picked me up when I went to work. I
Okay.
had tried to explain that to my attorney.
When's the
I don't
last
know.
time you actually drank then?
No, it's been almost about 2 years. I have been good. Like, I really can't even remember.
Ms. Gonzalez, I'll listen to you on the issues. You know that on DWI second, he's placed on ignition interlock, but you're
That
on
is
interlock
correct.
and antabuse.
That is correct, Your Honor. And I can file a motion with the court order to remove the antabuse, but I would ask at this time that the verbally that the court allow him to have the antabuse pill removed so that burden is taken away. Ignition interlock, as we know, it is required because of the charge. However, I would also ask that he be allowed into the program to waive those fees, considering the fact that he has been paying for it for over 2 years.
All right, and the court will order that you no longer will have to take antabuse. But Mr. Sanchez, if there's another violation, guess what I'm going to do? I'll take both ignition interlock and antabuse off, but I'll put scram on you. That's $300 a month.
I know that, Your Honor, and I'm not going to let you down. I don't want to let myself down either.
Your Honor, may I speak?
Hold on a second. I'll remove antabuse. Now, Mr. Edelman.
I understand the court's warning to Mr. Sanchez, but I would also ask the court that if there are any further violation reports submitted to the court, that Mr. Sanchez be given an opportunity to address those allegations before the court takes some form of official action.
I understand. Of course, that'd be my duty.
Thank you for stealing my thunder, Andrew.
I've been trying all day.
Justice is sometimes hard to find, isn't it, Andrew and Jessica?
Yes, Your Honor. So, and then with regards to the ignition interlock.
Yes, tell me about that. What were you requesting?
It's my understanding that there is a program that is available for indigent defendants to have the ignition interlock fees waived.
And what program would that be?
That's all the information I know. What I have done in the past for other clients is given a motion to the court to ask that he be allowed to have ignition interlock fees waived, similar to the GPS bond conditions. Those fees can be waived. I do not have details from pretrial services. I've only been explained over the phone that there is a program that they have and that sometimes there's a wait to get into the program. But other than that, I have no further details.
Patty Garcia, are you aware of such a program?
No, sir.
All right, the court will order that there be an inquiry to establish, and perhaps you can help us, Ms. Gonzalez, or even more unusual, Mr. Edelman, are you aware of such a program?
I am not. I am vaguely aware that there are provisions of the Code of Criminal Procedure that allow the court to waive the ignition interlock in the interest of justice for someone who is placed on supervision. I'm not aware of any such provision for pretrial bond conditions, but I'm looking, sir. And if there's anything, I'll bring it to your attention.
All right. I'm willing to give consideration to it, Ms. Gonzalez, but at this point, I am not aware that such a program exists. If I find out that there is one, having been informed on the record that Mr. Sanchez has now had ignition interlock for over 2 years, I would give very serious consideration to ordering that amendment.
And
So
thank you, Your Honor. And
nothing else.
I'll ask around with some colleagues. And I'll also try to remember which judge was the one that told me that it was a grant program. I'll see if I'll look through my old notes and see if I can find it. But I do know it was something that I learned recently within the past year, because it's always been my understanding that the courts could not waive ignition interlock fees because they were private companies.
Well,
so I do know it's out there. I just don't have the specifics.
Of course, the one alternative is to remove it outright. So, in the interest of justice, 2 years is more than enough.
Thank you. I'll look into that, and once I find something, I'll bring it to the court's attention.
All right, you were court appointed, right?
Yes, Your Honor.
So that means that by law, we've already found that he is indigent.
That is correct, Your Honor.
Mr. Sanchez, we're trying to alleviate some of your burden. Don't let us down.
No, Your Honor. And thank you so much.
You're welcome. All right.
Your Honor.
Ms. Garcia.
We actually have one more motion for the court.
The writ of attachment?
Bingo.
I thought I had ordered that already, Patty.
You did, Judge. But yeah. I was trying to let the court know that according to the D page, ignition interlock has been removed and put back on, and then removed again and put back on at several times during this gentleman's arrest, and then rearrest for pretrial violations.
If I may, Your Honor, I believe some of those were due to a different car, because I believe I had to file one of those to have it removed and then put back on. He needed a motion for the new vehicle.
Okay. All right. Well, that'll be my order as of right now. To Mr. Sanchez and your family, Jessica and all your loved ones, Merry Christmas to you. Be blessed, be well, and be safe, all of you.
And does anybody know what was ordered on the writ of attachment? Because I filed the request, and then I also filed the order.
He is to be arrested and jailed under $5,000 bond on condition of appearance in court as ordered.
Okay. Okay. All right. Okay. Well, with that, may we all be excused, Your Honor?
You are.
And Christopher, I'll call you once I learn something new about the ignition interlock. Okay.
Judge, may I stop YouTube?
Yes, ma'am, you may.